Welcome to this week's installment of Rochelle's Daily Wire, Video Edition. I am Bill Rochelle, ABI's Editor-at-Large. We're coming to you again from ABI's satellite office in the desert. Every week at the same time, we talk about the most significant events in the prior 7 days in terms of new bankruptcy decisions. The one that is most significant in terms of financial consequences is the opinion on January the 30th by District Judge Laura Taylor Swain in the restructuring of the debt of Puerto Rico under the statute known as PROMESA. Basically, Judge Swain is giving nobody a get-out-of-jail-free card, and no one is going to be able to take their marbles and go home quickly. In substance, she is saying that everybody is going to have to slog through the process, perhaps for years, in negotiating and confirming a debt restructuring plan. The holders of the general obligation bonds thought that they were entitled to a quick exit because, in their view, Puerto Rico had no right to do anything other with certain tax revenues than to pay them, and that all of the money in the meantime should be held in a segregated account. Well, Judge Swain responded by dismissing the complaint in its entirety, either for failure to state a claim or lack of subject matter jurisdiction. The second case of significance comes from a bankruptcy court in Birmingham, Alabama. It entails a 1967 decision by the Second Circuit in a case called Strauss du Parquet. In that case, the Second Circuit held that an executive, if he continues working or she continues working after the filing of a Chapter 11 petition, can contend successfully that continued work amounted to an implied assumption of the executory contract, thus giving that executive an administrative claim for, of all things, severance benefits, which may be very large. Judge Mitchell in Birmingham didn't go along with that notion, parted company entirely with the Second Circuit, and really this decision means that the Second Circuit ought to reconsider and, I think, revoke or overrule Strauss du Parquet because there has been an intervening change in bankruptcy law by the adoption of the Bankruptcy Code. I don't think the Second Circuit even has to sit en banc. Finally, we have very good news for Chapter 7 trustees in the Fifth Circuit, because the Court of Appeals in New Orleans held in a case called Lejeune that a trustee's commissions under Section 326 are presumptively allowable. That means that a trustee does not have to go through the process in every case of proving that the commissions are, shall we say, reasonable and necessary. In essence, what this means for trustees is that when you've got a lucrative case, you can collect your commissions in full, thereby making up for those other cases, many of them where you make more than nothing more than $60. Well, as I said, we come to you every week at the same time on Friday. Meanwhile, you can read more about these cases in my column, Rochelle's Daily Wire, on ABI's website, where there is also a wealth of other information extremely valuable for everyone involved in the bankruptcy and insolvency community. Until this time next week, thank you for joining us. We'll see you again in 7 days.